On the 19th of August 2025, a two-judge bench of Supreme Court of India, Justice Vikram Nath and Sandeep Mehta, sat down to decide the fate of six people nobody outside a classroom in Allahabad had ever heard of. Five peons, one driver, employees of Uttar Pradesh Higher Education Service Commission, hired between 1889 and 1992 to sort applications, dispatch files, and drive cars. Ordinary work, the kind of work that keeps an office alive without anyone ever writing a press release about it. They did that work for over 3 decades on daily wages. Not because the work was occasional, not because the office did not need them every single day, but because the state, twice in 1999 and again in 2003, declined to create permanent posts for them, citing in both cases financial constraints. The court did not accept that explanation, and the language it used to reject it is the reason why we are starting an episode about community health workers with a case about clerical staff in Allahabad. The bench held that a government cannot treat the same hands doing the same work for decades as temporary simply because sanctioning permanent posts would cost money. Financial stringency, the court said in substance, is not a magical word that excuses a state from organizing its workforce fairly. It coined, or at least crystallized, a phrase that is going to come up more than once in this episode. Perennial work deserves perennial posts. Where the task is recurring and indispensable, the label pinned to the worker performing it indefinitely cannot stay temporary. The ruling is now cited as Dharam Singh versus others versus the state of Uttar Pradesh. And if you read only the judgment, you would assume it belongs entirely to the world of daily wage government clerks and drivers. Except that within weeks, labor lawyers and legal commentators started doing something the judgment itself never explicitly did. They started pointing at a much larger, much older, and much more politically loaded problem. Because if perennial work deserves perennial post is now a live constitutional principle, then it has an obvious, glaring 10 lakh person application sitting right next door. A workforce that has been doing indisputably perennial, indisputably essential work for over 20 years and has never been called an employee. They are called ASHAs, accredited social health activist. And that word the government uses for what it pays them isn't a salary and isn't a wage, it's an honorarium. That word, honorarium, sounds almost quaint, warm even. Like a small gesture of appreciation you would give a guest lecturer for showing up. It is on paper a gift, voluntary, a thank you, not a paycheck. And the moment you accept that framing, an entire body of Indian labor law, the Minimum Wages Act, the Code on Wages, everything built to stop the state and private employers alike from extracting continuous work without continuous obligation, simply does not apply. Not because anyone forgot to write ashas onto it, but because the category they were placed in was built deliberately and with legal precision to sit just outside its reach. Notice what happened procedurally in Dharam Singh because it matters for how seriously we should take the doctrine. The state excuse wasn't static over decades. In 2024, the UP Higher Education Service Commission was itself restructured, merged into a successor body, and a government order that July proposed meeting future Class 4 and driver requirement through outsourcing rather than sanctions posts. In other words, even while the litigation was pending, the state's answer to this was that should this work be permanent was to redesign the organization chart so that the same work could be done by the same people who were not permanent. The court did not let that slide either. It held explicitly that a supervening structural structure cannot extinguish claims that had already accrued. The successor body inherits the predecessor's obligations, full stop. That detail matters for this episode because it's a purview of exactly the kind of maneuver we are going to keep encountering. Not a single decision to underpay a workforce, but a standing willingness to redraw categories, restructure schemes, and shift administrative machinery whenever the alternative is admitting that the work in question has quietly become permanent. This episode is not about whether ASHA workers deserve more money. And almost everyone, including the government's own ministers on record, will tell you that they do. This episode is about something colder and I would argue more important, how a modern, sophisticated, constitutionally literate state, a state whose own Supreme Court just spent 19 pages in August 2025 explaining why perennial work cannot be dressed up as temporary, continues to run one of its largest and most celebrated public health workforces on a world engineered specifically to make sure that none of the reasoning ever has to apply to them. That's not an oversight sitting in some unread footnote of a 2005 scheme document. It's a classification choice. And classification choices, when they are this durable, this convenient, and this expensive to undo, are never accidents. They are designed. Let's be precise about scale before we go any further because it's easy to talk about ASHA workers as an abstraction and lose the size of what we are actually discussing. There are over 10 lakh ASHA across India. More than 1 million women, roughly one for every 1,000 rural residents, embedded in villages as the first and often the only point of contact between a household and the formal health system. They run antenatal checkups, they facilitate institutional deliveries, they administer or escort children through vaccination drives. They track tuberculosis patients through months of treatment that fail the moment someone stops showing up to remind the family. During COVID, they were the people going door to door. Let's be precise about scale before we go any further because it is easy to talk about ASHA worker as an abstraction and lose the size of what we are actually discussing. In May 2022, the World Health Organization gave India's ASHA workforce its Global Health Leaders Award at the 75th World Health Assembly in Geneva. One of the 6 such awards handed out that year, alongside recognition for polio eradication workers in conflict zones. The Prime Minister publicly celebrated the award. That's not spin from a critique. That's the government's own framing of what this workforce is worth on the world stage. Here is the part that should feel like a contradiction and doesn't because we have all stopped noticing it. The same workforce being held up internationally as a model of community health delivery is domestically not legally recognized as having a job. And ASHA does not receive a salary. She receives a fixed monthly incentive. Currently 2,000 rupees from the central government in most states, topped up by a state level honorarium that varies wildly depending upon which state she appears to live in, plus a patchwork of task-based payment for specific activities, a fixed sum for facilitating an institutional delivery, another for completed immunization round, another for enrolling a household in the government scheme. Layer those together and total monthly earnings for an ASHA typically lands somewhere between 5 to 15,000 rupees a month, depending upon the state and how much task-based work she can generate in a given month. Kerala, after years of sustained strikes, raised its honorarium to 7,000 rupees of as early as 2025. And ASHA unions there are still demanding 21,000. Karnataka's ASHA union are pushing for alignment with the International Labour Organization minimum wage benchmark of roughly 28,000 rupees a month. Whatever number you land on, none of it is called a wage in the legal sense because none of it is attached to an employment relationship the law is willing to recognize. I want you to sit with this asymmetry here for a second because this is the frame the rest of the episode is going to use. This is not a story about a government failing to notice that a workforce is underpaid. India has noticed. There has been national strikes since 2018, a 69-day satyagraha in Bihar in 2022 that won a 1,000 rupee increase, a 21-day strike by 75,000 ASHA workers in Maharashtra in as early as 2024 who camped near the chief minister's residence until a 14-year-old demand strike state top-up was finally met. The government is not confused about the discontent. In August 2024, in a formal written reply in the parliament, the Ministry of Health and Family Welfare stated on the record that ASHAs were envisaged to be community health volunteers entitled to task and activity-based incentives. Not employees, not wage earners, volunteers by design from the start. The demand for a state top-up was finally met. It's worth dwelling for a moment on what an ASHA daily actually looks like. Not an appeal to sympathy, but because the texture of the work is that what makes a volunteer framing so structurally strange. The scheme was launched in 2005 under National Rural Health Mission with a design brief that on paper was genuinely thoughtful. Embedded a trained woman from community inside the community so that the health-seeking behavior could be shaped by someone the household already trusted, rather than by a stranger arriving from a district hospital. 2 decades on, that woman is typically the person who knows which household in her catchment area has a pregnant woman approaching term, which child is due for a second vaccine dose, which elderly resident has stopped taking tuberculosis medication because the side effects were unpleasant and nobody explained why that they mattered. None of that is casual, occasional, or supplementary labor. It's a kind of local, continuous institutional knowledge that a health system spreads through serious money trying to build when it doesn't already have embedded for free. And it sits structurally right next to a very different kind of a worker in the very same primary health center, an auxiliary nurse midwife doing clinically adjacent work, drawing a regular government salary, pension contributions, and service protection, and ASHA does not have. Not because her work is less continuous or less essential, but because she was placed in a different personal category at a different point in the system's design. That sentence is whole episode in miniature. It's a denial that ASHA workers work full days. Most put in 8 to 12 hours. It's not a denial that work is continuous, essential, and has been running for 2 decades since the scheme was launched in 2005 under the National Rural Health Mission. It's a claim about category. The government is not arguing. This work doesn't rise to the level of employment. It's arguing. We designed this work from inceptions in a category that never had to rise to that level in the first place. That's the referendum this cold open opened with. Every time a court, a commentator, or a controller adjutant general report raises the possibility that ASHAs might be functionally employees performing perennial public duties, the government answer isn't a factual rebuttal about the nature of the work. It's a jurisdictional one. This workforce was never inside the perimeter where that argument gets heard. And the pattern of resistance itself tells you something about how the state understands its own position. Every major concession in this workforce history has arrived only after sustained, organized disruption, never as a proactive administrative correction. The 2018 national strike demanded a 15,000 rupee minimum monthly salary. The government response was not to concede the salary framing, but to revise task-based incentive rates, a change that increased total earnings for some workers without ever touching the underlying classification. Bihar's 69-day Satyagraha in 2022 won a 1,000 rupee honorarium increase. 69 days of sustained protest for spread across a year works out over a little over 80 rupees a month. Maharashtra's ASHA workers camped up near the Chief Minister's residence for 3 weeks in 2024 before winning a top-up that unions have been demanding for 14 years. Read across the whole story. A clear shape emerges. Concessions arrive, but they arrive slowly, incrementally, and only in proportion to how expensive it becomes politically. Not to concede, which is a very different posture from a government that has looked at the underlying classification question and concluded on the merits that current arrangement is fair. It's the posture of a government managing a recurring cost center, not resolving the recurring injustice. That's the frame for the rest of this episode. We are not going to spend the next hour litigating whether ASHA workers are overworked. That case has been made repeatedly by the people far closer to the ground than I am. And it is not in a serious dispute. We are going to do something narrow and I think more useful. Trace the actual mechanism by which a single word, honorarium, has been engineered and defended across nearly 2 decades. 3 government worth of budget cycles and at least 2 major pieces of national labor legislation to keep this workforce permanently just outside the reach of the laws that would otherwise define what a fair employer owes a fair employee. 4 failure modes, each one load-bearing, each one on its own defensible in a committee room. Together, they add up to something that looks less like negligence and a great deal more like an architecture. Start with the word itself, because the word is doing almost all the legal work here, and it's worth understanding exactly how. India's core wage protection today sits in the Code of Wages 2019, 4 older labor laws, including the Minimum Wages Act of 1948, into a single statute. The Code on Wages guarantees a floor wage to employees. That word employee is a legal term of art, not a description of effort. It requires broadly an employee-employer relationship. Someone hired, someone directed the work, wages paid in exchange for labor rendered under that direction. An honorarium, by contrast, is defined both in ordinary usage and in how government schemes deploy it as a voluntary payment made in recognition of service, not a contractual wage owned for labor performed under direction. The distinction almost sounds philosophical. In practice, it's the entire ballgame. If you are an employee, the code on wages applies, and there is a statutory floor beneath which your pay legally cannot fall. If you are a recipient of an honorarium, you are outside that code perimeter entirely, not underpaid relative to the floor, because there is no floor to be under. There is a second definition wall sitting behind that first one, and it is worth naming because it shows how deliberately layered this architecture is. Even the older Industrial Dispute Act of 1947, the Statute of 2006 Anganwadi ruling leaned on, defined its core protected category, workmen, narrowly around employment in an industry. Courts have spent decades litigating what counts as an industry for that purpose, and government welfare schemes delivered through community workers have consistently sat outside that definition, on the reasoning that a health outreach scheme isn't an industrial or commercial undertaking in the sense of Act contemplates. So even before you get to the honorarium versus wage distinction in the Code of Wages, there is a prior gate. Is this kind of enterprise labor law was built to police? And ASHAs, like the Anganwadi workers before them, have historically been read as sitting outside that gate too. 2 separate definitional walls, stacked, each one sufficient on its own to keep the claim from landing. There is a pattern worth naming here because it recurs everywhere in how this state relates to the categories it has drawn around its own obligations, and it's worth a belief cross-reference to the data protection episode, where we discussed how DPDP Act's compliance obligations landed unevenly on hospitals, with the entities easiest to formally categorize as data fiduciaries, absorbing most of the compliance burden. The thorough line in both cases isn't hypocrisy exactly. It's the legal categories. Once drawn, tend to persist based on how convenient they are to the administration rather than being continuously retested against how well they still map onto reality. A category drawn in 2005 when the ASHA scheme launched as a genuinely experimental, unproven community health intervention made a defensible kind of sense. Nobody knew yet whether this workforce would become permanent, essential infrastructure. 2 decades, a global pandemic, and a WHO award later, the facts on the ground have moved dramatically. The category hasn't moved at all. This isn't a new trick, and ASHA weren't the first workforce it was tested on. Anganwadi workers, the roughly 1.4 million women who run India's early childhood nutrition and education centers under the Integrated Child Development Service scheme, hit this wall exactly 2 decades ago. In 2006, a Supreme Court bench of Justice S.P. Sinha and Markande held that Anganwadi workers were not entitled to minimum wages on the reasoning that Minimum Wages Act applies to workmen in industries and in Anganwadi center isn't an industry in the same act contemplates. That 2006 ruling is the ancestor of everything we are discussing today. It established at the highest judicial level that this work is socially essential and this work is legally waged are two separate questions, and that Indian courts were, at that time, willing to answer the first one generously and the second one narrowly. Here is where it gets interesting and where the mechanism starts to show its edges. In 2006, position did not hold forever. Courts did not stay still, and neither did the state relationship to its own precedent. In 2022, in Maniben Mangalbhai Bharatiya versus Union of India, the Supreme Court held that Anganwadi workers, despite still not being formally recognized as regular government employees, were nonetheless entitled to gratuity under the Payment of Gratuity Act. Because the 2013 National Food Security Act had by then rooted statutory nutritional entitlements through the ICDS structure. Anganwadi staff, which gave their function a legal weight it had not had in 2006. Watch what happened here. The court did not say, you were an employee all along. We were wrong. It found a narrow statutory hook, gratuity specifically, and extended it while leaving the larger wage question essentially untouched. That's not incidental. That's the pattern. Indian courts, when they are moved on to scheme worker classification at all, have moved one entitlement at one time, through whatever specific statutory doorway happened to be open, rather than through the single sweeping declaration that scheme workers are, in fact, employees. And every time the door opens only that far, the core firewall, the honorarium versus wage line survives intact for the next fight. Which brings us back to the Dharam Singh case and to why I opened this episode with a case that never mentions ASHA workers even once. Legal commentators writing in the months after August 2025 judgment, most notably a column in the bar or and bench of one of the India's more closely read legal publications, began explicitly connecting Dharam Singh's perennial work deserves perennial post doctrine to the ASHA and Anganwadi honorarium question, arguing that when the state creates multiple categories of people performing functionally identical public work, some on regular payrolls with provident fund and insurance, others surviving on honorarium, that differentiation has to be intelligent and rationally connected to a legitimate object under the equal protection guarantees in Article 14 and 16 of Constitution of India. And they point out something sharp. Dharam Singh itself contains language holding that fiscal convenience alone is not a legitimate object for that kind of differentiation. If that principle is taken at face value and applied one step further than the judgment itself went, the honorarium classifications for millions of scheme workers started to look less like a settled legal category and more like the kind of financial stringency talisman. The court spent 19 pages telling Uttar Pradesh it could no longer wave around. There is a genuine legal complication sitting underneath all of this that deserves naming plainly. Because the reason Dharam Singh's own bench had to do real interpretive work rather than simply citing precedent and moving on. A 2006 Constitution Bench decision, Secretary State of Karnataka versus Uma Devi, had held in different contexts that courts generally should not order regularization of irregularly appointed daily wage workers because doing so risks bypassing the constitutional requirement that public employment be filled through open, transparent recruitment processes. For nearly 2 decades, Uma Devi has been the precedent state government's reach for whenever a court is asked to convert temporary engagement into permanent employees. Precisely because we didn't hire you through proper process is a much cleaner legal defense than we don't think your work matters. Dharam Singh had to explicitly distinguish itself from Uma Devi to reach the outcome it reached, holding that the UP worker were not asking skip the recruitment rules. They were challenging the state's refusal to create sanction post at all, which is a logically prior question. That distinction is real, and it's also narrow enough that a future bench faced with an ASHA specific case could plausibly go either way depending upon exactly how the claim is framed. Which is precisely why this fourth failure mode, the case that would test the honorarium classification head on, has not been brought in the specific, carefully constructed form it would need to succeed. But this is the mechanism, the actual answer to why this arrangement produces the outcome it produces. Not just the fact it does. No court has been yet asked to make that extension in a case squarely about ASHA workers themselves. Dharam Singh was about daily wage peons and a driver in one state education commission. It is binding precedent on its own facts and persuasive at its best facts it never actually decided. Until an ASHA specific case reaches a bench willing to draw that line explicitly, the honorarium classification survives not because it has been affirmatively upheld against this exact argument, but because the argument in this exact form has not been forced a court's hand. That gap between a doctrine that clearly could apply and a doctrine that has actually been applied is not a courtroom accident. It is the single most cost-effective piece of legal architecture the state has. A firewall that doesn't need active defending. Only the accumulated fact that nobody has yet successfully breached it in specific case that matters the most. There is one more layer to the definitional firewall worth pulling apart before we move to the money, because it explains why even sympathetic officials genuinely trying to help tend to reach for the same limited toolkit. Once a workforce sits outside the code of wages, every subsequent policy conversation about improving their situation gets funneled through the language of welfare and incentive enhancement rather than wage negotiation. Because welfare and incentive setting are executive, discretionary powers a ministry can exercise unilaterally. Budget permitting, while wage setting is a statutory floor cut, that would be a legal entitlement enforceable independent of any minister's discretion. That's not a small semantic difference. A discretionary honorarium hike is something a government can announce, take credit for, and just as easily decline to repeat next year if the fiscal picture tightens. A statutory wage floor is something a government owes continuously regardless of who is in office, how the budget looks in a given year. Every time policymakers reach for let's raise the honorarium instead of let's set a wage floor, they are, whether they intend to or not, choosing to keep this workforce compensation inside a more revocable, more discretionary category, which is precisely the category the honorarium classification was built to guarantee in the first place. The second failure mode is not about definitions. It's about who actually supposed to pick up the phone when ASHA worker in Kerala or Karnataka asks for a raise. And it's a mechanism you'll recognize immediately if you are listening to the episode I did on resident stipend, because it rhymes with that one, but inverted. ASHAs are engaged under the National Health Mission, which is a centrally sponsored scheme, meaning the central government designs it, partly funds it, and issues guidelines while state government implements it and crucially retains discretion over top-up payments. The central government fixed incentive to every ASHA nationwide currently sits at 2000 rupees a month. Everything above that is a state level honorarium, set independently by each state government, funded substantially, sometimes entirely out of the state budgets. That is why Kerala's ASHA, after a decade plus of agitation, sit at roughly 17,000 rupees monthly honorarium, while ASHA in less fiscally aggressive or less politically pressured states can be earning closer to the bare central floor plus whatever task-based incentive they can generate per month. Now watch the accountability structure this produces, because it's a genuinely elegant piece of blame diffusion, whether or not it was built with that intention. When ASHA unions demand a raise, state governments, including pointedly Kerala's own health minister, even while presiding over a state that has moved further than most, routinely responds that ASHAs are a central government scheme. So it's a center's obligation to set fair play. The center government position consistently is that states are free to top up the honorarium as they seem fit and frequently do. Both statements are narrowly true. Neither government is lying. And that's exactly the mechanism. This is a two principle, one agent problem where the agent, the ASHA worker demanding better pay, has no single principle she can hold accountable because responsibility has been split across jurisdictional seam that neither side has full authority or full incentive to close alone. Economists have a clearer name for the underlying dynamic than shrug. Even if shrug is more honest word for what it feels like from the ground. It's a coordination failure produced by fiscal federalism, where the cost that both government benefit by keeping low has been structured so that raising it unilaterally is a politically costly for whichever government moves first. While the combined fiscal room to fix it, split correctly, is well within what either level of government spends elsewhere without controversy. Look at how unevenly the honorarium component actually lands across the country, because the variance itself is evidence of the mechanism at work. Kerala, a state with a long history of organized labor activism and a left-aligned political tradition that makes ASHA strikes especially costly to ignore, pushing its honorarium to 7,000 rupees after a year of agitation. Karnataka's unions are still fighting towards the ILO benchmark. States with less organized labor infrastructure, weak fiscal capacity, or less political appetite for confrontation with public sector unions sit closer to the bare central floor. That spread isn't a story about which states value community health workers more. It's a story about which states have workforces organized enough and fiscal room flexible enough to unilaterally absorb the controversy. Consider the numbers. The National Health Mission central allocation for 2025-26 was roughly 37,000 crore rupees, later revised upwards to 39,000 crore rupees across full appropriation cycle, a silver of health ministry budget that crossed 1 lakh crore rupees for 26-27. Raising the central ASHA incentive component meaningfully, even doubling it, would represent a genuinely small fraction of that total. It is not, in other words, primarily a scarcity problem. It's a sequencing problem. No state wants to be the one whose unilateral hike becomes the new demanded floor in every neighboring state in the next strike. And center has limited appetite to set a national floor that immediately becomes the binding across 28 states and 8 union territories with wildly different fiscal capacities. If it sounds familiar, it should. It is the same structural logic I walked you through in the labor economics episode on resident stipend monospi. Just wearing a federalism costume instead of a hospital administration one. There the mechanism was single buyer, the state medical education health system, facing a captive supply of labor with nowhere else to sell its skills, which lets the buyer suppress pay below what is a competitive market would produce, because residents has no exit option. Here the mechanism runs almost in reverse. Instead of one buyer facing captive supply, you have two buyers, centers and the state, each of whom can plausibly claim the other holds the primary responsibility, which produces underpayment not through market power over a captive workforce, but through an accountability vacuum neither principal has full incentive to fill. Different mechanism, same outcome, a workforce with essentially no institutional actor whose job is unambiguously is to raise their pay. In a resident stipend case, works because the buyer has too much power over the captive seller. In the ASHA case, the federalism structure works because no single buyer has enough exclusive ownership of the liability to force the move alone. Two ways of arriving at the same place. The workforce that everyone agrees to is underpaid, and no single institution actor who can be pointed to as the one who can fix it without political cover from someone else moving first. Under the National Health Mission standard cost sharing arrangements, states are expected to fund a meaningful share of cost schemes themselves, with more favorable sharing ratios extended to hill and northeastern states in recognition of their weaker physical capacity. That structure was designed reasonably to build in some states ownership of outcomes rather than making the center fully responsible for a scheme it cannot administer directly on ground. But the same design that produces healthy local ownership over, say, primary health center staffing also produces exactly the ASHA compensation stalemate, because some states' ownership quietly becomes enough ownership that a center can point to, but not enough obligation that an individual state feel forced to move first. This is also, not coincidentally, why the honorarium classification from segment 2 is so useful to both levels of government simultaneously, which is part of why it has proven so durable. If ASHA were reclassified as employees, entitled to a statutory minimum wage under the Code of Wages, someone would have to be the employer on record. And that determination alone would force the center-state negotiation that both sides have to spend 2 decades successfully avoiding. The ambiguity isn't just about what ASHAs are owed, it's about who specifically owes it. Keeping them volunteers, receiving a voluntary honorarium, and the question of employer liability never has to be solved, because volunteers, by definition, don't have an employer in the first place. The definitional firewall from segment 2 and the federalism shrug in this segment are not two separate failures happening to coincide. They reinforce each other. The classification prevents the liability question from ever crystallizing, and the absence of a clear liable party is exactly what makes the classification so hard to dislodge in court, because there is no single defendant a plaintiff can squarely aim at. The third failure mode moves from who pays to how they pay, and this is where we run into a mechanism most listeners of this podcast will already have a name for: Goodhart's law. Once you turn a measure into a target, the measure stops being a reliable measure, because people, quite rationally, start optimizing for the number instead of the underlying goal the number was supposed to represent. The economist who usually credited with the sharpest version of this insight, Charles Goodhart, was originally writing about monetary policy, not healthcare workforces. But the logic transfers cleanly to any system where a proxy for value gets paid instead of the value itself. Pay for the institutional deliveries, and you'll get more institutional deliveries counted. Whether you get more of the underlying thing the payment was actually meant to encourage, a healthier, more trusting, better served community, is a separate question the metric was never built to answer. There's an information asymmetry sitting underneath this too, and it is worth naming precisely because it explains why the state keeps choosing task-based metric over a flat salary even when the officials are individually well aware of the trust-building work that isn't being captured. The state cannot cheaply observe how much relationship building, persuasion, and quiet crisis management an individual ASHA does in a given month. That information lives entirely inside her daily interactions with the household, invisible to any centralized reporting system. Whether the state can cheaply observe what is a delivery got recorded as institutional, whether a vaccination round shows full coverage, whether a scheme enrollment form was filled. Faced with that asymmetry, A rational administrator, even a well-intentioned one, will design a payment system around the observable half of the work, not because the unobservable half does not matter, but because you can't build an auditable national payment architecture around something you structurally cannot verify at scale. The honorarium plus incentive model isn't a failure of imagination. It's a predictable output of trying to pay fairly under conditions of genuine information asymmetry, using tools built for observable outputs rather than unobservable effort. Recall the structure. An ASHA's income is a small fixed component plus a stack of task-based incentives, a fixed rupee amount per institutional delivery facilitated, per immunization round completed, per household enrolled in a scheme, and so on across a long menu of activities defined by the ministry. On paper, this sounds like public sector design. Pay for outputs, not just presence. And you get a workforce naturally oriented towards the outcomes the healthcare system actually needs. In practice, it does something subtly different. It makes an ASHA income, not just her effort, depends upon how countable her work is. Facilitating an institutional delivery generates a payment. Sitting with a grieving family after a stillbirth does not. Escorting a child through vaccination round generates a payment. The hours spent building the kind of community trust that makes a household willing to disclose a tuberculosis symptom in the first place, rather than hide it out of stigma, generates nothing directly. Even though that trust in the entire reason the ASHA model works better than a purely clinical outreach model would. This is the honorarium's second function, and it's easy to miss if you only look at the total rupee figure. It is not just a classification that avoids minimum wage law, it's a payment architecture that lets the government describe its ASHA spending as performance-linked and efficient because task-based incentives are definitionally tied to specific, auditable, reportable outputs. A finance ministry evaluating national health mission spending can point to immunization round completions and institutional delivery counts and show real, measurable public health gains per rupee spent, which is true and which is also precisely why nobody senior has a strong institutional pressure to convert this model into a flat, unconditional salary. A salary is harder to defend line by line in a budget presentation than countable outcome metrics is. The honorarium plus incentive structurally isn't just legally convenient, it's narratively convenient. It lets the state describe underpayment as an efficient, outcome-driven scheme design rather than what it is also simultaneously is an underpaid workforce whose invisible labor happens to correlate with the visible labor the incentive structure was built to reward. Take a concrete example of how this plays out. Under Janani Suraksha Yojana, the safe motherhood schemes that routes cash assistance through institutional delivery, and ASHA earns fixed task-based payments specifically for facilitating an institutional delivery. Getting a pregnant woman to a hospital or a health center to give birth rather than at home. That's a genuinely valuable public health outcome, and paying for it makes sense in isolation. But notice what it does to our incentive at the margin. A delivery that happens smoothly in a facility on schedule generates income. A difficult pregnancy that requires 4 extra hours of home visit to convince a nervous or resistant family that ultimately still ends in a safe institutional delivery generates the same single payment as the delivery that took 1 visit and no persuasion at all. The incentive structure cannot distinguish between an hour of work and 40 hours of work as long as the countable outcome at the end looks the same. That's not a design flaw anyone intended maliciously. It is what happens when you build a payment system around outputs that are cheap to verify in a domain where the actual difficulty of underlying work varies enormously and is not itself verifiable at all. There's a cross-reference worth making to the hospital AI procurement episode here too, because the underlying mechanism, a budget category mismatch, rhymes closely with what's happening here. In that episode, hospitals struggled to fund AI pilots past the pilot stage because the spending did not neatly fit into any existing budget line. Not because capital expenditure, not quite an operating cost, so it fell into the gap between the categories that made it easy to fund once and hard to fund continuously. The ASHA incentive structure has the mirror image problem. The work itself doesn't fit neatly into the payment category. Relational, trust building, community embedded labor does not map onto a line item the way completed vaccination round does. So it doesn't get funded continuously. It gets funded only in moments where it happens to produce a countable adjacent output. In both the cases, the state is not refusing to pay for the value it doesn't recognize. It's structurally unable to pay for the value it cannot easily recognize, and the categorization gap quietly becomes a funding gap. The 43% figure is worth sitting here too. A study cited in reporting ASHA compensation found that as of the reference year measured, only 43% of ASHA had received their monthly incentive on regular, predictable basis, meaning a majority were dealing with delayed, irregular payments on top of an income that was already structurally uncertain because so much of it depended upon how much countable task they managed to complete and get verified that month. Layer irregular dispersal on top of a task contingent pay, and you get a workforce whose income isn't just low, it's unpredictable in a way that makes it nearly impossible to plan a household budget around, which is a distinct harm from low pay itself, and the honorarium framing conveniently obscures because incentives were delayed bureaucratically as an administrative hiccup rather than a wage payment failure with legal consequences, which is exactly what it would be classified as if ASHA were, in fact, employees under the Code on Wages. There is a cross reference worth making here to the accreditation episode because the mechanism is a cousin on one we discussed with NABH. A measurement system built around what's cheap and legible to count applies to a domain where the most valuable work is often hardest to count. NABH measures structured because structure is auditable. It undermeasures outcomes because outcomes are messy and slow. The ASHA incentive structure measures discrete, verifiable tasks because tasks are auditable. It undermeasures relational, trust-building community work because trust does not generate a line item. In both cases, the metric did not fail by accident. It succeeded brilliantly at making the state spending look efficient and its outcome looking strong, while quietly starving the exact kind of labor that made the underlying model worth celebrating with a WHO award in the first place. The fourth failure mode is the newest, and in some ways the most revealing, because it shows the state actively building new legal categories in real time, and each time and finding a reason not to place ASHA inside the one that would help them. In September 2020, Parliament passed the Code on Social Security, consolidating 9 older social security laws and for the first time in Indian labor law, formally defining a gig worker and platform worker as legal categories distinct from traditional employees, largely in response to the rise of app-based delivery and ride-hailing work. The code created a National Social Security Board, established welfare funds for unorganized gig and platform workers, and set up registration mechanism through what would become a e-shram portal. It was genuinely a significant expansion of who Indian labor law was willing to formally see. And labor economists and researchers, including K.R. Shamasundar at Xavier Labor Relations Institute and Meena Abraham at Azim Premji Institute, pointed out something the drafting process quietly skipped. ASHA and Anganwadi workers, who had by 2020 spent the better part of the year as a literal formal frontline India's COVID-19 response, were left outside the code ambit entirely. Not accidentally omitted through an oversight in a 900-page consolidation exercise, but structurally excluded because the code's new categories were built around how a worker is engaged through an app, through a platform, through an informal market relationship, and government scheme worker engaged directly by the state through a decade-old public health mission does not cleanly fit in any of the boxes the code went to the trouble of newly inventing. Here is the mechanism stated precisely. Every time Indian labor law expands to formally recognize a category of precarious work, ASHA workers becomes eligible for that recognition only if they happen to fit the specific shape of the new category. And the categories keep being drawn around forms of precarity that resembles gig economy platform work, not scheme-based government engagement. This is not hypothetical caution on my part. The 2025 case that opened this episode makes the same point from the completely different direction. Dharam Singh's own reason explicitly invoked a prior 2024 Supreme Court judgment, Jaggo versus Union of India, which had specifically criticized what it called a gig economy mindset, creeping into a public sector engagement practices, warning that treating public employment like gig workers corrodes the dignity of the constitution it is meant to protect. So you have simultaneously a labor code in 2020 that invents gig worker as a protected category and pointedly leaves ASHA worker outside it, and a Supreme Court in 2024 and 25 warning against treating public sector work like gig work, while the workforce actually sitting in that exact gap, more stated directly than any gig worker but less protected than any recognized employee, remains uncategorized by both. It is worth pausing on how deliberately the Code on Social Security's new categories was constructed, because the specificity is the tell. The code did not just gesture vaguely at informal work. It built out an registration architecture through the eShram portal, created dedicated welfare funds financed in the part by mandatory contribution from digital aggregators pegged to a percentage of their turnaround, and set up a national social security board with defined seats for aggregator representatives and worker representatives alike. That's a serious, well-resourced piece of institutional design built in direct response to a genuine, well-documented gig economy precarity. And every part of that design, the aggregator turnover funding mechanism especially, assumes a private commercial intermediary sitting between the worker and the end beneficiary of their labor, which is exactly the relationship an ASHA does not have. There is no aggregator taking a cut of ASHA's labor whose turnover could be taxed to fund her welfare. There is only the state directly, which means the very funding mechanism that makes the code's gig worker protection real and resourced simply has no equivalent lever to pull for scheme workers, even if the parliament wanted to extend the same formal recognition for them. It is worth being precise about what unorganized worker already meant under the older law of 2020 code replaced, because the irony sharpens at this point. The Unorganized Workforce Social Security Act 2008, one of the 9 statutes consolidated into the 2020 code, already defined unorganized worker broadly enough to include home-based, self-employed workers with no former employer at all. ASHA in principle could have been read into that broader, older category well before 2020 code gig worker provisions ever existed. That they largely were not, in practice, folded into welfare schemes machinery the 2008 Act enabled, tells you the exclusion was not really about precise wording of any statute. It's about administrative habit. Successive pieces of legislation across successive governments have each had an opportunity to explicitly fold scheme workers into whatever new protective category was built, and each one has left that door partially open, if it opened at all. That gap is not a coincidence, and it's not laziness in legislature drafting either. Updating 9 consolidated labor codes to explicitly include ASHA and Anganwadi workers under the Unorganized Worker Registration and Welfare provisions of 2020 code, already created for other precarious categories, would have been a comparatively modest drafting change. It did not happen. And the reason it did not happen is the same reason the honorarium classification has survived 2 decades of strikes, parliamentary questions, and now a Supreme Court doctrine that arguably already applies to it. Every category in India's labor law has built since 2005, when the ASHA scheme itself launched, has been built with enough specificity to not quite reach backward and capture the 10 lakh women already working under older, vague, cheaper label the state assigned them to start. The category keeps moving. ASHA keeps standing exactly where they were. Push the comparison one step further and the patterns become almost mechanical in its predictability. Every time a new form of precarious labor becomes visible and politically salient enough to demand its own legal category, daily wage government staff in the 1980s and 90s, Anganwadi workers through 2000 gig platform workers in 2020, the state has eventually built a category to formally recognize it. What it has never done in 20 years is go back and audit whether workers placed in the oldest, vaguest and least defined category scheme of volunteer receiving an honorarium actually still belong there, given how much the nature and the permanence of their work has changed since the category was assigned. New precarity gets named. Old precarity gets grandfathered into whatever label it started with on the assumption, never actually tested, that the original classification was correct and simply needs better reinforcement rather than re-examination. That symmetry, forward motion for new categories of vulnerable work, inertia for older ones, is worth naming in its own right, even though it is not one of the four numbered failure modes. It's closer to the meta pattern that makes the other four possible in the first place. A legal system that periodically retests its own older classifications against currently facts would likely to have caught this by now. One that only builds new categories forwards and rarely revisits old ones backwards won't. Not because anyone decided ASHA specifically should be left behind, but because nothing in the machinery is built to ask the question at all. One last thread before we leave the failure modes and turn to the steelmen. Notice how each of the four mechanisms we have just walked through makes the other three cheaper to maintain. The definitional firewall from the segment 2 removes the legal pressures that would otherwise force the center state liability question in the segment 3 to be solved. The federal ambiguity in the segment 3 makes it politically easier to keep the compensation inside the discretionary, incentive-based structure based in segment 4. Because a statutory wage floor would require the center state liability split to be settled first, which nobody wants to do unilaterally. And the ASHA incentive structure in segment 4 by making ASHA compensation look performance linked and efficient in budget documents reduces the political pressure that might otherwise push Parliament to close the categorical gap we mentioned in segment 5. None of these four failure modes needed to be designed together to reinforce each other cleanly. They did not have to be coordinated to function as a system. They only had to each independently be the path of least resistance for the institutional actor facing that particular decision. That's what makes this genuinely a matter of mechanism design rather than a single bad actor's choice. No one office, no one minister, no one court is responsible for the whole architecture. Each layer was added by a different actor, solving a different narrow problem, and compounding effect is nobody's individual fault and everybody's collective outcome. Point 6. The counter argument. Now the steelmen. Because a diagnosis this uncomfortable deserve to be tested against its strongest opposing case, not a straw man. Point 1. And this is the real one. This is genuinely harder to fix than a single villain-driven narrative suggests, because the fix is not a signature. It's a fiscal, administrative restructuring with cascading effects the government hasn't fully modeled, at least not publicly. Reclassifying 10 lakh ASHA as formal employees under the Code of Wages does not just mean paying them more. It means determining an employer off record across a state center scheme that has spent 20 years deliberately avoiding that determination. Extending provident fund and gratuity obligations, opening the door to service condition litigation, and this part matters, potentially triggering a parallel claim from roughly 1 crore other scheme workers, the Forbes India reports cites. Anganwadi workers, midday meal workers, and others currently sitting in the same volunteer and not the employee category. This is not a 10 lakh person fiscal decision. It's arguably a 1 crore person one, because precedent does not stay contained to the workforce that wins it. A government moving cautiously here isn't necessarily moving in a bad faith. It may genuinely be trying to avoid the fiscal commitment it cannot yet size accurately. And there is an administrative dimension to that caution worth taking seriously on its own terms, not just as fiscal nervousness. Formal employment status does not mean higher pay. It means service rules, transfer policies, disciplinary procedures, grievance redress mechanisms, all the machinery that comes with converting a scheme relationship into an employment relationship. Building that machinery credibly for a workforce this large and this geographically spread is a genuine administrative undertaking, not a paperwork formality. A state that rushed reclassification without building the surrounding administrative capacity to actually honor it could end up with a workforce nominally upgraded on paper but functionally no better protected in practice. Areas owed but not paid. Grievance mechanism that existed in statute but not in any district office and ASHA could actually walk into. Moving carefully isn't the same thing as moving in bad faith, even when the caution ends up serving the state fiscal interest too. Point 2. Genuine credit where it's due. The government has not been static on ASHA welfare. Even within the honorarium framework, it has refused to abandon. The extension of Ayushman Bharat PMJ health insurance coverage, 5 lakh rupees per family per year, to all ASHAs and Anganwadi workers and helpers, announced in the year 2024 interim budget and expanded through 2025-26 budget cycle, is real. Material benefit that did not exist a few years ago. And it moves exactly the direction critics are asking for, treating this workforce as deserving of the kind of social protection formal employees typically receive, even without conceding the employment classification itself. The WHO recognition was not just symbolic diplomacy either. It reflects a genuine, internationally verified assessment that ASHA model, whatever its compensation failures, has produced real community health outcomes that better funded, more formally staffed system in comparable economies have struggled to match. Crediting this compensation failure does not require discrediting the underlying model. And it is worth being honest about what the community embedded design actually gets right. Independent of pay, health systems in comparable economies have spent enormous sums trying to manufacture that kind of local trust, and ASHA carries by default because she has already lived in the community she serves. This is not a small design achievement dressed up in WHO language for PR purposes. It's a genuinely hard problem in public health delivery that this model solved structurally, at scale, faster and cheaper than any other alternative delivery mechanism had managed elsewhere. The critique in this episode is about compensation architecture and not about whether the underlying idea of community embedded health work was sound or not. It clearly was. Point 3. And this is the one that makes most work of the diagnosis, not takedown. Framing this podcast insists on. The system is visibly, if slowly, self-correcting through exactly the channel you would want a constitutional democracy to use. Courts and organized labor, working the scenes the honorarium classification left open. And it's worth noting that the self-correction isn't limited to compensation. The extension of PMJ health coverage to ASHA and Anganwadi worker itself is a form of state recognizing through social security side door rather than the wage classification front door. That this workforce carries risk a genuine volunteer arrangement would expect anyone to bear uncompensated. That's not nothing. A government fully committed to the volunteer framing in every particular wouldn't feel obligated to ensure a volunteer's health at state's expense. The fact that it does suggest that even within the government, the honorarium classification is understood at some level as a legal convenience rather than an accurate description, which is itself a kind of tacit admission that strengthened rather than undermined this episode's core claim. The 2022 gratuity extension for Anganwadi workers happened because litigants found a specific statutory hook and pushed it through. Kerala's honorarium hike to 7,000 rupees happened because ASHA unions organized, agitated and made the political cost of inaction higher than the fiscal cost of action. The Maharashtra strike in 2024 won a 14-year-old demand after 21 days of sustained pressure. And Dharam Singh itself, whatever it narrows facts, represent the Supreme Court that is visibly less tolerant to the financial constraint as an all-purpose excuse that was in 2006 when it first drew the line that excluded Anganwadi workers from minimum wage protection in the first place. The doctrine is moving. It's moving slower than any ASHA worker wanting her next irregular disbursement would like. And it's moving through litigation and strikes rather than through a single decisive legislative act. But the honorarium classification has survived every challenge so far. Is a different claim from the honorarium classification is stable. And conflating those two would be its own kind of dishonest. There is a fourth, quieter piece of steelman worth naming before we land the honest position because it's the argument a genuinely thoughtful defender of the current system would make last. After the fiscal, credit, and self-correcting points, predictably itself has value, and a rapid court-forced classification would, in the short term, destabilize a system that currently reaches every corner of India reliably, even imperfectly. Litigation-driven change is blunt. A court ruling that ASHAs are now employees tomorrow won't by itself specify funding mechanisms, phase-in timelines, or transition arrangements for roughly 1 crore comparable placed scheme workers would immediately cite the same precedent. It would simply create a legal entitlement that the administrative machinery might take years to catch up. In the interim, producing exactly the kind of arrears owed but unpaid to limbo state governments already are. Right now, sitting with respect to Dharam Singh's own UP litigants, who are still wanting their compliance affidavit. A careful defender of gradualism isn't necessarily defending the honorarium classification on its merit. They are simply pointing out that the speed and the justice don't just arrive together, that a poorly sequenced win can look on ground indistinguishable from a loss for years at that time. Here's the honest position. Holding both halves at once, none of this Steelman changes the underlying fact that classification was chosen, is defended, and continues to be defended, specifically because it avoids legal and fiscal consequences that would follow from calling the work what it functionally is. The federalism is complexity is real, but it is also a complexity the state had 2 decades and multiple committees reports to solve, and it has not. In part because unsolved complexity is politically cheaper than resolved liability. The genuine benefits, PMJ coverage, the WHO awards, the incremental state level raises are real, and they are also exactly the kind of adjacent, non-classification threatening concessions a system makes when it wants to visibly respond to the pressure without conceding the one point that would actually cost it the most. And the self-correction through courts and strikes is genuine and also slower than it needs to be precisely because the classification firewall from segment 2 was built to survive incremental challenges. It was built to require a case squarely on point, brought by the right plaintiffs, reaching the right bench, and the kind of case takes years to construct even when the doctrine that would decide it in workers' favors already arguably exists. The blueprint, 5 proposals, ordered from most achievable to most aspirational. Each one targets a specific failure mode from earlier in this episode, and none of them require dismantling the ASHA scheme, the National Health Mission, or the community-based model that earned India the WHO award in the first place. 1. Mandate regular verifiable disbursement timelines with statutory penalties for delay, independent of classification fight. This targets the incentive structure failure from segment 4, specifically the finding that only 43% of ASHA were receiving payments on predictable schedule. You don't need to resolve whether an honorarium is a wage to fix when it arrives. Treat disbursement delay the way Code on Wages already treats wage payment delay for recognizable employees, with defined timelines and automatic penalty interest for late dispersal, without waiting for the classification questions to be settled first. This is the cheapest, fastest, least politically contested item on the list, and it directly addresses the harm of the income unpredictability, which compounds the harm of low income itself. It also requires no new legislation architecture. It can be implemented through National Health Mission program guidelines and state-level administrative circulars using disbursement infrastructure that, in the digital payment era, already largely exist. The 43% regularity isn't a technology problem, it's a priority problem. And priority problems are fighters' fastest ones to fix once someone with authority decides they matter. Second, create a single joint center state ASHA compensation council with binding formula-based responsibility splitting. This targets the federalism shrug from the segment 3. Rather than leaving the center state top-up relationship informal and blame diffusing, establish a standing body, modeled loosely on the GST Council's cooperative federalism structure, with a binding formula for what proportion of any agreed increase in the center versus each state contributes, indexed to the state physical capacity. This does not require new money by itself. It requires removing the coordination failure that currently lets both levels of government point at each other indefinitely. Cooperative federalism bodies of this kind have already proven they can function in India on genuinely contentious fiscal questions. The GST Council routinely negotiates binding revenue sharing outcomes across the states with widely different fiscal capacities and political alignments. There is no structural reason the same negotiation architecture could not handle a compensation formula for a single centrally sponsored scheme if the political will to convene it existed. 3. Extend the Code on Social Security's unorganized worker registration and welfare fund provisions explicitly to the scheme workers, closing the drafting gap identified. This is a legislative amendment, not a full recategorization as formal employees. A smaller lift than a code on wages coverage, but that brings ASHA and Anganwadi workers inside a welfare fund and a registration architecture that already exists and is already funded for gig and platform workers. It answers the category keeps moving problem directly by finally including scheme workers in the newest category built to protect precarious labor rather than leaving them stranded between the old categories and the new ones. This would require Parliament to solve the funding mechanism gap identified. Since there is no aggregator turnover to tax, the welfare fund contribution for the scheme workers would need to come from a general National Health Mission allocations rather than the aggregator levy that funds gig worker protections. But that's a solvable drafting problem, not a conceptual one. And it's a far small legislative lift than any amending the code on wages itself. Fourth, commission and this time publish a full costed actuary study of reclassification ASHA and comparable scheme workers as formal employees under the Code of Wages, covering the full roughly 1 crore worker population the Forbes India reporting references. This targets the harder to fix than it looks problem by removing the excuses that the fiscal exposure is unknown. Right now, the government caution is defensibly precisely because nobody outside government has credible public number of what full reclassification would cost across the whole scheme worker population. A published methodological transparent study, even one that confirms the cost is large, would convert an open-ended fear into a specific negotiable fiscal questions, which is a prerequisite for any serious legislative move on the next point. Point 5. Bring a squarely on-point constitutional challenge using Dharam Singh and Jaggo precedent explicitly to test whether the honorarium classification survive Article 14 scrutiny when applied to functionally continuous, indispensable public health labor. This is the most aspirational item, and this whole episode has been building towards because it's the one that will finally solve the definitional firewall from segment 2 rather than working around it. The doctrine material already exists. Perennial work deserves perennial post. Financial stringency is not the talisman. Warning against a gig economy mindset infecting public engagement. What doesn't yet exist is a case built specifically, deliberately, and well enough to put ASHA honorarium classification itself squarely in front of the bench willing to decide. That case is buildable. It simply hasn't been built as yet. It would need to be deliberately the way Dharam Singh own bench did by framing the claim as a challenge to the state's refusal to create posts rather than a request to bypass the recruitment and draw the Article 14 comparison directly against the comparable placed, formerly salaried workers, and A&M in the same primary health center would do to make the intelligent differential argument concrete rather than abstract. None of that is a legal innovation. It's an assembly work, using tools the courts have already forged. Taken together, notice the sequencing logic across all five. Proposal 1 buys immediate relief without touching the classification question at all. Proposal 2 removes the accountability vacuum that lets the compensation conversation stall for decades. Proposal 3 closes the newest legislative gap using the architecture that already exists and is already funded for a comparable category of workers. Proposal 4 converts an open-ended fiscal fear into a specific negotiable number, which is a precondition for any government to spend on Proposal 5 without moving blind. And Proposal 5 is where the doctrinal case this whole episode has been building. Dharam Singh Jaggo, the Article 14 comparison to formerly salaried co-workers in the same primary health centers finally gets tested squarely rather than gestured at the sidelines by the legal commentators drawing analogies. Each proposal makes the next one more achievable. None of them requires anyone to concede that the ASHA scheme itself has failed. All five are aimed precisely at the label, not the labor. None of these five requires ending ASHA scheme, replacing community health workers with a different delivery model, or dismantling anything the WHO gave India an award in 2022. Every one of them is comparable with the version of the system that already works. They just stop asking that the system's least protected workers to keep subsidizing it with one thing a legal fiction was designed to make free. The difference between what perennial work is worth and what a scheme document for 2005 decided to call it. Let's go back to where we started. A bench in Delhi in August 2025 looking at 6 daily wage workers in Uttar Pradesh and deciding that decades of calling perennial work temporary it cares whether the work is perennial and whether the label attached to it was chosen for a legitimate reason or a convenient one. We have spent this episode tracing 4 separate mutually reinforcing ways that a single convenient word, honorarium, has kept that doctrine from ever being pointed, squarely and successfully, at the 10 lakh women it most obviously describes. 4 failure modes, and notice how none of them alone would sound damning in a committee room. A definitional distinction between an employee and a volunteer, reasonable on its face. A federal structure that gives state discretion over top-ups, reasonable in principle. A payment model that rewards measurable outcomes, reasonable by the logic of most modern public administration. New label categories built around specific shape of gig economy precarity. Reasonable given what the problem Parliament is actually trying to solve in 2020. Each one, defended individually, survives scrutiny. It's only when you stack all 4, walk the definitional firewall, the federalism shrug, the incentive structure, and the moving category one after the another, the way this episode did, that is what looked like the 4 unrelated administrative choices resolve into a single durable outcome. A workforce the state has never once had to formally admit it employ. So here is the question I actually want to leave you with, and it's not, should ASHA workers be paid more? Almost nobody who looked closely disagrees with that. The question is, the next time you hear a government describe a workforce as volunteer, who receive an honorarium rather than a wage, in healthcare, in education, in any scheme of this country runs on the back of its people had decided, by category rather than by the fact not to call employees. Will you hear that as a description, or will you hear it for what it usually is? A choice made deliberately, defended consistently, and built from the very first line of the very first scheme document to survive exactly the kind of scrutiny it's now finally slowly starting to receive. That's it for the episode of Let's Break In. If this changed how you read the word honorarium, the next time it shows up on a government document, that's good. That's the whole point. Drop in comments and find me on LinkedIn. I read everything.